Good afternoon and welcome. This is Molly Zimmerman, the Associate Director of the NYS-sponsored New York State Science and Technology Law Center. We come to you from the Syracuse University College of Law, and I'm happy to introduce you today to Professor Shubha Ghosh, the newly appointed Director of the Technology Commercialization Law Program here at the College of Law. He is also the Crandall Melvin Professor, and he comes to us after nearly 20 years of law school teaching, most recently at the University of Wisconsin. He is a member of the California Bar and the United States Supreme Court Bar. I'm happy to turn it over to Professor Ghosh.
Thank you, Molly, and welcome to our first, after a long time, webinar. I'm glad that you were able to participate, and this will be the first of many that we'll be having over the next several months and over the year. So I'm delighted to have joined the center. I'm looking forward to getting involved with these and other activities. So today we're going to talk about two cases that are pending before the U.S. Supreme Court. The oral arguments were heard back in February, I think February 23rd of this year. And as of this morning, the Supreme Court hasn't issued its opinion, but we probably will hear something within the next month or so. And at issue in these cases, they're consolidated cases, Halo versus Pulse and Styker versus Zimmer, has to do with what's the standard for willfulness in order to obtain enhanced damages for patent infringement. And the subtitle for the talk is Catching Trolls or Pirates, and I basically took that description from one of the attorneys in the oral argument, who was representing Zimmer, representing the respondent side, as really kind of encapsulating what's at issue in terms of the decision in this case. The idea is there are either two kind of bad actors, if you're thinking about this as some sort of a cartoon or video game or something. They're the patent trolls. I don't like the phrase trolls, but this was the one that was used by Mr. Phillips. The ones, patent owners who just simply bring a lawsuit in order to get settlement or to extort some sort of payment based upon the patent. And pirates, parties out there who realize there are patents, but they go ahead and infringe or make use of the patented technology anyway. And the question is what the standard should be in order to get enhanced damages. Which one are you trying to get, trolls or pirates? And so the petitioners, the ones who are representing the patent owners, want to go after the pirates, and those representing the respondents, who tend to be the alleged infringers in patent cases, say you need to have a high standard for enhanced damages in order to be able to thwart the trolls from just bringing frivolous litigation in order to get not only basic patent damages, but also the treble damages. So that's really what's framing this discussion. It seemed to frame the oral argument in the Halo case. And so let's talk a little bit about this. My plan is to give you some background to the case and give you some sense of the broader issues and the broader context. And I hope to stimulate questions and discussion. We can't speak one-on-one, but we've got an interactive system, as you may know, and so I look forward to getting your questions, and feel free to send your questions as they come up. We're going to be going for probably a little bit over an hour, but it's probably good to have questions as they come up, and then I can either slow down or backtrack or even go on some related tangents on this topic. So catching trolls or pirates, what's at issue? The first thing that's at issue is 35 U.S.C. Section 284 of the Patent Act, which deals with recovery for damages as a remedy in patent infringement cases. And really what's at issue is the underlying sentence, if everybody can see that. The first paragraph talks about what maybe everybody's familiar with, compensatory damages for patent infringement. And then the section goes on to say that when damages are not found by jury, the court shall assess them, so that this can be either a jury question or a judge question, and that can be important for things that we'll discuss later on. And then the issue is, in either event, whether the judge or the jury determines damages, the court may increase the damages up to 3 times the amount found or assessed. And so the operative issue here is court. Once again, the court can be either the jury or judge, and as you'll discuss, the issue of enhanced damages can either go to a jury or be determined by the judge through summary judgment. But the operative word here is may. What exactly is the standard for granting enhanced damages? And one of the things the court has said, consistent with other areas, is that enhanced damages are a type of punitive damages. They may have some compensatory function, but largely their function is to somehow punish the infringer for engaging in egregious or other conduct. And so the court can increase damages up to 3 times in certain situations. And the way in which the courts have looked at this is, since this is punitive, the idea is that there has to be some willful or other type of conduct by the infringer to warrant damages. And so the question then is, what is that standard for willfulness? And if that standard is met, then the court will go on to the next stage to figure out how the damages should be enhanced. Will it be the full 3 times, or will it be some lesser amount? And to look at other factors that might get to whether enhanced damages would be the right way to deal with the willful behavior. So as many of you out there may know, the issue of willfulness has been before the court, and it goes back to a decision by the Federal Circuit in re Seagate. And the citation is at the bottom of the slide, 497 F. 3rd, 1360, 2007 Federal Circuit decision.
Just take a quick time out. There seems to be a sound issue.
Okay, sorry about that. Should I start from the beginning, or? Okay. Well, I hope the sound issue has been resolved and people can hear me now. Just a quick recap. We're going to talk about the Halo versus Styker and a Zimmer case. That's a Halo versus Pulse and the Styker versus Zimmer case that are before the U.S. Supreme Court, oral argument back in February. And the issue is, what is the standard for willfulness that's required in order to obtain enhanced damages under Section 284? And so the precedent that's under scrutiny here is in re Seagate that goes back to 2007. It's a Federal Circuit decision that basically says that there's sort of a 2-prong approach to determine whether the infringer has acted willfully. And that entails both an objective prong and a subjective prong. The objective prong is basically to see whether there is any cognizable defense or any justification for the infringer's conduct, and then also a subjective element that basically gets to what the infringer's mindset was when both engaging in infringement and then also engaging in the litigation. And I'll unpack that a little bit, because that's the issue as to what exactly are the elements of this objective and subjective standard. But under Seagate, the courts typically look first at objective factors, and if there are no objective bases to find willfulness, then the courts will not go to a subjective standard at all. And so we'll talk a little bit about that, whether the courts have gotten Seagate right, whether that's the right approach. But the patent owners in this case, who have been denied excessive enhanced damages, are basically saying that the Seagate standard is too high, that it makes it very difficult, if not impossible, to get enhanced damages, and the standard should return to one that existed before the 1952 Patent Act that allowed the courts to look at a totality of the circumstances. And one of the issues, just to highlight now, is whether the willfulness should be based upon the infringement or whether it should also include the litigation conduct. And there is this concern that an infringer may have acted willfully. So at the time of infringement, the party might have said, the patent, we don't care about the patent, we're just going to go ahead and use the technology. But then in the course of litigation, the patent does get invalidated, and the court ultimately concludes that no enhanced damages should be granted. Or putting it more completely, the patent may be questionable, so it doesn't get completely invalidated, and therefore the court says that there was some sort of a reasonable basis to question patent validity, and therefore that works against willfulness. So the question then is, from the petitioner's standpoint, is when willfulness should be determined, whether it's purely a question for the at the time of infringement, or whether post-infringement and specifically litigation conduct should also be included. And the best way, the petitioners say, to deal with these issues is then to allow the district courts to exercise their discretion and look at the totality of the circumstances, as opposed to just simply dividing it up into objective and subjective prongs. So the petitioners are asking for the Seagate case to be overruled and to be replaced with this totality of the circumstances standard. And in support of this sea change in the law, the petitioners, the patent owners in this case, refer to Section 285, which deals with the award of attorney's fees. And this provision is fairly straightforward. It says that the court, in exceptional cases, may award reasonable attorney fees to the prevailing party. And the Supreme Court in 2014, in a case called Octane Fitness versus Icon Health, again overruled the Federal Circuit standard for finding exceptional cases and awarding attorney's fees. Pre-Octane Fitness, the Federal Circuit also used a two-prong objective-subjective analysis to determine when a case was exceptional. And so the court would look at both an objective basis for the party's behavior. So did the infringer have some sort of valid defense? And then also look at subjectively whether the infringer was acting in an egregious fashion. And in Octane Fitness, the Supreme Court rejected that two-prong approach, analogous to the approach that you see in Seagate, to basically say that totality of the circumstances is what the court should look to in making a determination as to whether a particular case is exceptional for the purposes of awarding attorney's fees. So the patent owner's arguments in this case, so Halo and Styker, the petitioners, is largely an argument by analogy. Their basic view is that the Seagate opinion has this very rigid two-factor, two-pronged test that does not give the district court enough discretion and allows certain infringers to avoid unfairly the payment of willful damages. And by analogy, they're saying that the court got rid of a very similar two-pronged test in Octane Fitness in the context of attorney's fees. So whether you believe in that analogy or you buy that analogy, that seems to be at the heart of what's going on in this particular case, and it's worth fleshing that out. And to kind of give us a little bit more grounding, I present in this slide the various questions that were brought in the cert petition before the U.S. Supreme Court. And so Halo and Styker, they both lost at the Federal Circuit level. The Federal Circuit basically denied them enhanced damages, though in very different contexts. And so Halo and Styker individually submitted cert petitions to the Supreme Court on these issues, and then the Supreme Court, in granting the cert petitions, consolidated the cases. So here are the main questions that the Supreme Court is considering. The first question is from the Halo petition, and the last two are from the Styker petition. And so the Halo question is whether the Federal Circuit erred by applying a rigid two-part test for enhancing patent infringement damages under 35 U.S.C. Section 284. That is the same as the rigid two-part test this court rejected last term in Octane Fitness LLC versus Icon Health for imposing attorney's fees under the similarly worded 35 U.S.C. Section 285. And as you can see, Stryker's question 1 is very similar. Has the Federal Circuit improperly abrogated the plain meaning of Section 284 by forbidding any award of enhanced damages unless there's a finding of willfulness under a rigid two-part test, when this court rejected an analogous framework imposed on Section 285, the statute providing for attorney's fees awards in exceptional cases. So again, this question is getting at the need for a more flexible totality of the circumstances approach in 284, much like the one the Supreme Court has adopted in octane fitness for 285. And to get a sense of what the totality of the circumstances might entail, the second question that was raised by Stryker in their cert petition is illuminating. Does a district court have discretion under Section 284 to award enhanced damages where an infringer intentionally copied a direct competitor's patented invention, knew the invention was covered by multiple patents, and made no attempt to avoid infringing the patents on that invention? And so the operative thing about this question is the way it mixes objective and subjective elements. So under the current approach in Seagate, the court would first look to see whether there was objective evidence, such as copying, such as whether there was multiple patents, such as whether there were attempts to avoid infringing the patents, including whether the patent itself was invalid or whether there were any attempts at design arounds. Those would be objective. And if the court does find some objective basis for willfulness, then it has to go ahead and look at the subjective elements. In this particular case, in both Halo and Stryker, the facts are pretty interesting. In Halo, the patent owner lost on summary judgment. The court did find that there was infringement within the U.S. of Halo's patent by Pulse, but the court ruled that since there was some uncertainty as to the validity of Halo's patent, especially on the issue of non-obviousness that Pulse raised pretty forcefully during litigation, that there was no objective basis to say that the infringer had acted willfully, since there was some basis to say that the patent was invalid, but not enough to actually invalidate the patent, and therefore the court granted summary judgment in favor of Halo. Stryker is a different case procedurally because that went to a jury trial. The jury did find both infringement and willfulness and did award enhanced damages, but then the Federal Circuit reversed the jury finding. So as we'll see, and we'll elaborate upon, the issue of enhanced damages can come up in many situations. It can be done by the judge on summary judgment, or it can be done by jury. And that raises some interesting questions about how flexible and how defined the standard should be. It also raises some questions about appellate review. And it's worth mentioning that here because it'll come up again when we discuss the oral argument. Both in Halo and in Stryker, in the Federal Circuit opinions that basically denied the patent owners the enhanced damage award, the Federal Circuit says that the standard of appellate review for a determination under 284 is de novo. And that's a little bit confusing, especially when you're dealing with a jury finding of willfulness. And so this issue did come up in oral argument, and I want to flag it here, but it may be a question that will go unanswered by the court. It'll be interesting to see if they go so far. But notice here that the court has not taken the question about what the standard for appellate review should be. And so since the patent owner's arguments are based upon a analogy with octane fitness, it's worth pointing out that when the court decided octane fitness in 2014, they also decided a companion case having to do with the standard of review for Section 285. And in that case, the Healthmark case, the court did rule on the same day as it came out with its ruling in octane fitness that the standard for Section 285 will not be de novo, but abuse of discretion. So this is actually one of the things that's kind of confusing in this case. There is a lot of discussion in the oral argument about standard of review, but it's not a question that the court has granted cert on, but it's certainly a question that the court has to address especially if it does overturn the Seagate decision. So with these questions in mind, it's worth looking at some of the things that we have as background. Let's talk a little bit more about octane fitness in Section 285. Basically, in octane fitness, the Supreme Court rejected a standard that looked to objective and subjective criteria to determine when a case was exceptional. And Halo and Stryker here are arguing that that same two-factor test is at issue in Seagate and has the same sorts of problems. It basically has not been very effective in trying to catch willful infringers or the pirates, and therefore, just like in octane fitness, the court should move more towards the totality of the circumstances. Now, it's probably worth spending some time here talking about that analogy. I've done some research on the Section 285 issue. I spent a year in Washington, D.C. working for the Federal Judicial Center in 2014 and 15 and looked at some of the cases on 285 before octane fitness and after. And there is a close parallel between findings of willfulness under 284 and a grant of attorney's fees. So the two issues, willfulness under 284 and grant of attorney's fees under 285, are not independent issues. They certainly are connected to each other. And so this analogy that the patent owners are making is not a completely inapt one. It makes sense, and clearly they're trying to find some room in order to persuade the court to overrule Seagate based upon what the court did in octane fitness. So that's all perfectly understandable, but it's also worth emphasizing how Section 285 differs from Section 284. The first big difference, of course, is that Section 285 is available to both successful patent owners and successful defendants in patent infringement suits. So there's a symmetry there that doesn't exist for willfulness. Willfulness is only given to the patent owner upon showing some sort of a finding of infringement by the defendant. So it's a very different type of situation. It's meant to compensate, as we mentioned before, and also have a punitive function to benefit the patent owner, while the fee shifting under Section 285 is meant to make whole or compensate whoever the successful litigant is in a patent infringement suit, whether it's the patent owner or the defendant. And if you look at other aspects of this, we mentioned the compensation role and the deterrence role of 284 and the enhancement of damages. The area of attorney's fees may not have as much of a role in compensation. Certainly it compensates the successful litigant for the costs of bringing the lawsuit. There might be some deterrence effect and so forth in terms of whether the lawsuit is brought to begin with, either by the patent owner or by the defendant, let's say in a declaratory judgment action. But the analogies do sort of break down fairly quickly, except for kind of the similarities of the two-factor test and so forth. And some of those misfit, if you will, between the two come up in the oral arguments. So here's an example, or here's the patented issue that was owned by Halo. It's in the electronics field. It's an electronic surface mount package. It's basically meant to hold the electronic packaging for various types of devices. And there was an interesting issue in this case regarding the validity of this patent. The litigant, Pulse, had brought in prior art to challenge the non-obviousness of this particular patent. And even though that was not successful, there was a real question as to whether this really should have been granted in the first place. I should also point out that one other issue that came up was the sale, the nature of the infringement. Pulse in this case had made some sales overseas as well as sales in the U.S. And the question is whether the sales overseas, since they originated in the U.S., would count as infringement. So under Section 271A, infringement entails sales within the United States. And the district court found that some of the sales that Pulse had entered into actually occurred overseas and therefore could not be the basis for infringement. And so one of the issues that Halo had sought cert on was this question about what constitutes a sale within the United States. The Federal Circuit had affirmed on that issue, and the Halo therefore was seeking some clarification from the Supreme Court on this issue, but the Supreme Court did not grant cert on that question. So I just highlight that issue here because it's still pending. It may come up again in the future before the Supreme Court and does raise some questions about why the court granted cert in this case. It clearly was interested in this willfulness issue and really wanted to resolve that, especially when it saw it both in the Halo case and in the Stryker case. So the other patent at issue is the one that was owned by Stryker as assignee, and that it was enforcing against Zimmer. And that case went all the way to the jury. The technology in this case has to do with a washing device that's used in surgical procedures to basically clean wounds and clean other aspects of the surgical procedure. You can see a picture of the device at the bottom, irrigation handpiece with built-in pumping pump. And so the idea behind this was to basically facilitate surgical procedures. Zimmer was found to infringe on some of these claims. The jury did find enhanced damages based on its finding of willfulness, but the Federal Circuit reversed. And the Federal Circuit reversed largely on the grounds that Zimmer had introduced some testimony regarding the validity of this patent. Ultimately, the patent was not invalidated. But nonetheless, when the Federal Circuit looked at the objective criteria, the court did not find any objective criteria as a basis for willfulness, and therefore it did not have to look at the subjective criteria. And during oral arguments, Zimmer's counsel, actually Zimmer's counsel is the one responsible for the trolls versus pirates distinction that I talked about at the beginning, does admit, and I think this is clear from the record, that Zimmer did copy the washing device, this pump device that Stryker had invented, but copied it before the patent had issued. It wasn't clear whether it had done it while the patent application had been filed or not. So there was an admission of copying, but it was before the patent was granted. And then, of course, that copying continued after the patent was granted, and that became the basis for the patent infringement lawsuit. And I mentioned this just to emphasize again the point that both Halo and Stryker are making, that patent owners are making in this case. Zimmer did copy. That should be a pretty strong factor in terms of finding willfulness, and it should be a strong factor both objectively and subjectively. But the Federal Circuit emphasized the fact that there was some basis to wonder whether this patent was valid to begin with at all, and therefore that reasonable belief, or if you want a good faith belief in patent validity that seemed to exist, or at least the objective evidence to support such a belief in patent invalidity would work against willfulness. So we'll see this discussion about good faith belief again when we look at the oral arguments in a few minutes. But for those who've been following patent litigation over the last couple of years may remember that in 2014 there was another decision by the U.S. Supreme Court, Como versus Cisco, which dealt with the question of whether a good faith belief in patent invalidity would be a defense in an inducement lawsuit under 271B. And the Supreme Court ruled, I believe the vote was 6-2, against that defense existing for inducement. Basically, the reasoning was that since inducement is secondary liability, the belief of the infringer, the direct infringer, would not be relevant for the knowledge that's required by the indirect infringer. But in its opinion, the court does have a dicta. I would describe it maybe as dicta, maybe a little bit stronger than dicta, but at least a good discussion as to whether good faith belief in patent invalidity would be a defense for direct infringement. And the court suggests that it would not be. So at issue in Halo and Stryker, just to emphasize, is not whether good faith belief in patent invalidity is a defense or not. The question is whether objective evidence of patent invalidity would be a basis for not granting enhanced damages on the grounds that there was no willfulness. And the patent owner's view is that's somewhat getting the cart and the horse backwards. That we don't want a situation where a competitor just kind of rolls the dice and basically says, we're going to just infringe, and if we get caught, we'll just get very good counsel to come up with prior art, and if they can invalidate the patent, great. If they can't, at least we'll have a basis to avoid enhanced damages. That's exactly the scenario that the patent owners want to avoid, and they argue can be avoided by moving more towards the totality of the circumstances, looking at subjective and objective, looking at what happened at infringement as well as what happened in litigation, and putting that all in the mix. It seems like the court is, at least the Federal Circuit, is more concerned about trolls, so that, in other words, the owner of a patent that is of questionable validity bringing a lawsuit in order to get extortionate value by having such a high standard in order to get enhanced damages. Okay, so with that in mind, I'll be glad to take any questions as we move on to discussion. Let me talk a little bit more about the oral argument. And what I want to do for the remainder of our time together is talk about the oral argument in some detail, look at the opinions of the various justices and what they say about this particular case. And then I want to end our discussion with a fairly extensive look at some of the implications of this opinion for practice, both in terms of litigation, both in terms of cease and desist letters, as well as how we think about technology commercialization and startups together. So let's then look at the oral arguments. Where were the justices during oral argument? You had the full bench participating during the oral argument in February. Justice Scalia had passed away by then, so he had not obviously taken part in this, and will not have input in this particular. Did not have input in this particular set of cases, though he was made in preparation of oral arguments, may have informed some of these justices. So there's a possibility of this being a 4-4 split. And so we need to keep that in mind as we look through the various questions by the judges. And of course, if there's a 4-4 split, then the Federal Circuit law will continue. Seagate will continue to be the law, and this issue might come up in the future. There's a possibility that the justices might ask for a rehearing next year, depending upon how split they are. But my general overview, before I go into the weeds a little bit, is that there seem to be some clear lines of agreement. And so I would not expect a 4-4 split. You never know what's going to happen during conference and so forth. But we'll see how the alignment works. Is there a question, Molly?
There is a question.
Sure.
Now that we have IPRs and PRGs, shouldn't the defendant be required to take that route to avoid treble damages? rather than just plead a belief in patent invalidity at the trial.
Okay. So this was, I responded to that question by saying initially that there isn't such a requirement, but as Molly reread the question, it was a should question rather than a could or a has to question. We will have another, just to kind of put in a little word from the sponsor, I guess we're the sponsors for this, we will have another of these webinars in the end of April that deals with that issue regarding IPRs and PGRs in the Quozo case that's in front of the Supreme Court as well, that has to do with the various standards and the relationship between the administrative proceedings and the litigation. If I were to look at it as a should question and also to kind of foreshadow what we're going to do in that webinar in about a month, there are good reasons to require it, but there are also probably maybe more compelling reasons not to require it. There are jurisdictions that do require the defendant to go through the administrative proceedings or to have some sort of administrative review of a case before it goes to the courts. But the system for infringement is a judicial one. It's based upon an adversarial type system rather than an administrative type system. And so the general view, I think, would be that the defendant should be able to raise those defenses and not necessarily lose them or be required to go through some sort of administrative proceeding as opposed to the judicial proceeding. But it's a really important question, and I think we can continue that discussion. Is there another question, Molly, or no? Okay. So let's go back and look at the general overview. As I was saying before, I don't think there'll be a 4-4 split, but you can see the justices aligning it up in a particular way. And so you've got Justices Sotomayor and Kagan asking a number of questions that seem to point to protecting the interests of the patent owners, and therefore really emphasizing a need for enhanced damages. I think especially Justice Kagan, she's raised this type of questioning in other cases. If you want to overrule the precedent, what's going to replace it? And there seemed to be a concern that a totality of the circumstances approach might not really pass muster. In other words, it might be too open-ended and maybe even less protective. And I may be reading a little bit into the questioning here of patent owners' rights than the existing standard under Seagate. And so their lines seem to be against the totality of the circumstances approach, more in favor of the respondents. The Roberts approach or the Roberts line of questioning seem to be more in favor of having more room for the district court discretion, which would be an approach that's more in favor of the patent owners. And so there's a lot of discussion in his questioning, if you read it closely, that goes back to the language of the statute. And let me just pull that up really quickly. Notice what's at issue in this case is that one sentence, and really at issue is the word may. There's nothing in the statute that says anything about willfulness, nothing that says anything about a subjective or objective test. The willfulness analysis, I think, is maybe required based upon what the courts have said about enhanced damages in other contexts. But Justice Roberts seemed to be emphasizing the may here, and therefore suggested, and I think pretty strongly suggested, that the Federal Circuit may have taken an approach that is too rigid and does not give room for the district court. Justice Roberts did not directly address the question of standard for appellate review, but presumably in line with this deference to district court discretion, would also question the de novo standard of review, which, as I mentioned earlier, is an open question here. But I think Roberts you have probably on the other side compared to Sotomayor and Kagan, in terms of the interests of the patent owner and so forth. Then you've got Breyer, who does take a view that you want to deter frivolous patent litigation. And Therefore, the view would be that, I want to correct myself here. Roberts would be aligned with Sotomayor and Kagan in terms of lowering the standard and allowing more district court discretion. All three of them together would be on the side of patent owners. I may have spoken a bit quickly there. With respect to Breyer makes it very clear that the goal, or really the big policy goal, is to deter frivolous patent litigation. And the way to deter frivolous patent litigation is to make it harder for a patent owner to get enhanced damages. And the way to make it harder for the patent owner to get enhanced damages is maybe to stick to the Seagate rule and the approach that the Federal Circuit has adopted. And so this is interesting to compare with his approach, and he didn't have an opinion in the Octane Fitness case, but having signed on to that opinion, or being involved in that particular set of cases, this kind of highlights an asymmetry between 284 and 285 in terms of dealing with frivolous patent litigation. 285, if you're concerned about frivolous patent litigation, you might want to make it harder for enhanced damages to be obtained, so that patent owners are less likely, especially ones who may be trolls, are less likely to bring suit. On the other hand, you might want to have a lower standard in order to get attorney's fees shifted under 285, which is the kind of approach that was adopted in Octane Fitness. So this again emphasizing how the analogy between Octane Fitness and this particular pending case, the Halo case, does not totally hold up. So just looking at this tally, we have 3 justices in favor of the patent owners, 1 justice in favor of the respondents in this case. And I mentioned these 4 justices here because many of the questions were coming from them throughout the oral argument, but you did have some others that arose, and these justices may be a little bit harder to completely pin down in terms of trying to figure out whether there would be a split or not. Justice Ginsburg seemed to be concerned about moving away from the existing precedent, and many of her questions that were pointed towards, well, what should the standard of appellate review be here? Which made her wonder a little bit about, just reading a little bit into the questioning, as to whether the Federal Circuit has the right approach upon reviewing these types of cases. The questions may have been pinpointed more towards who has the burden, whether it's the petitioner or respondent here, regarding how the law should be shifted or how the objective or subjective prong should be used. But this was sort of her line of questioning. Justice Alito, had a bunch of questions regarding opinion of counsel, especially Section 298, and how these would deal with intent. So Justice Alito was, had written the Akamai decision and was involved heavily with this question about willfulness and induced infringement, and so has a particular interest, it seems, based upon some of the previous cases on this issue of intent in patent law. And he raised this partly, I think, in terms of trying to understand exactly if there's going to be more of an emphasis on subjective standards, as the patent owners seem to be wanting to do. In other words, did the infringer say, patent be damned, I'm just going to go ahead and do this? What exactly, how exactly would a patent owner prove that? I mean, what kind of evidence would be needed to show intent? And so this is where the opinion of counsel in Section 298 come into play. Section 298 of the Patent Act basically codifies the Nor-Bremse decision, having to do whether opinion letters from counsel could be introduced in order to show willfulness. And so this, as many of you know, about a decade or so ago, was a fairly controversial issue. It pitted the need for evidence to show willfulness based upon opinion of counsel versus attorney-client privilege issues. And the Federal Circuit battled with it, basically coming down on the side that these opinion letters would not be admissible, and then this becomes codified in Section 298. And so Justice Alito, I think, raises these issues and these sets of questions partly to emphasize how difficult, if not impossible, at least in his mind, it would be to actually show intent. So that suggests possibly a vote again against the patent owners in terms of moving away from the Federal Circuit approach in Seagate to one that would look at the subjective factors a little bit more closely. So again, trying to keep the tally, it seems to be at least looking at the previous four justices, Sotomayor, Kagan, and Roberts, who seem to be in favor of the patent owners. Breyer and Alito seeming to be more against the patent owners in this case. Ginsburg, a little bit hard to figure out, but maybe leaning towards the patent owners. We may not see that many fissures here. Justice Kennedy really emphasized the punitive and compensatory role of enhanced damages and their importance in the remedies available for patent owners. Again, I don't want to read too much into the tea leaves, suggesting maybe some leaning towards the petitioners in this particular case. Again, the strongest questionings came from Sotomayor, Kagan, Roberts, especially Breyer. And there you see sort of a 3-1 in favor of the patent owners in this case. And then when you start bringing Justices Ginsburg, Alito, and Kennedy into the mix, we might find a slight way in favor of the patent owners and an overruling of Seagate. Justice Thomas did not ask any questions here. If I were to speculate, his opinions have in general been more favorable to patent owners, so it may be likely that he would rule along the lines of probably Justice Roberts and what I've speculated with regards to Justice Sotomayor and Kagan. Again, you can never make predictions, but I think it's unlikely that this will be a 4-4 decision. And so there's a good chance that Seagate would get overturned in this particular round of in light of what we saw in the oral arguments. So, are there any other questions, or Molly? Or no?
No.
Okay. So let me. We've got about 10 or 15 minutes left. Let me talk a little bit about some of the takeaway issues for discussion and just for our understanding of this particular case. I think there are four sorts of takeaways. I mean, the basic problem I think that comes across is what is the standard for willfulness? How is that going to affect litigation and litigation strategies? But it also has some implications for transactional work. How do you deal with cease and desist letters? How should you try to act in order to avoid enhanced damages? Are there things that you can do regardless of what the final standard might be? Let me just kind of work through these and talk about some of the take-home messages might be. The first has to do with patent law reform and views on litigation. That goes back to the very beginning, the very title of this talk, trolls versus pirates. To go back to Mr. Phillips' designation in his oral arguments on behalf of Zimmer. Here you see again the courts trying to deal with some fundamental issues in the patent statute as they apply to the broader debates about patent law reform. In Octane Fitness, certainly this question about patent trolls and frivolous patent litigation was an issue in terms of what the standard should be for awarding attorney's fees. And as many of you know, there's pending legislation. It's gone through the House, and we're waiting to see what happens in the Senate regarding changing the standard, again, for attorney's fees. Essentially, what the reform would be if it goes through is to have attorney's fees be automatic unless the case is unexceptional. It's sort of shifting the presumptions that exist under current 285, where the attorney's fees are granted only if they're exceptional. The new regime or proposed regime would be one where attorney's fees would be automatic unless there's a reason not to shift attorney's fees. So it's not completely clear to me whether that makes that big of a difference, especially since attorney's fees are often very much at the end of the game. Unlikely that they're awarded at summary judgment. It's possible. But usually what courts have looked at in attorney's fees cases have been things like willfulness issues and egregious conduct in litigation and so forth, in terms of making almost like a super Rule 11 type provision. So maybe at the margins it would have some effect on the patent troll debate and frivolous litigation, but I'm a little bit more skeptical about this. 284 might potentially have more of an impact, and certainly these policy issues informed not only the oral argument, but the broader debate regarding what the standard should be for willfulness. Again, there's an asymmetry here that has to be emphasized. The award of enhanced damages inure to the benefit largely of the patent owner. And so if they're too easy to get, then it may stimulate or create incentives for more patent litigation, especially frivolous litigation in search of treble damages. On the other hand, if the concern is that the patent laws are under-enforced, that there are many people who are making copies of inventions without necessarily entering into licensing or appropriate conduct, such as design around, then the higher standard would seem to be promoting that type of behavior. In terms of the broader debate, though, the focus is on the frivolous litigation. It's always largely been on the frivolous litigation, not necessarily the litigation that should have been brought but didn't get brought, or was brought but should have been successful but wasn't successful. Clearly, if there has been infringement, a lot of the work or heavy lifting might be done by compensatory damages, independent of enhanced damages. That might be enough of a deterrence in many cases. And there is this broader issue, independent of patent trolls, that was raised by the previous question as to challenges to patent validity. Should a potential innovator, tech startup, entrepreneur, whatever you want to call it, just simply take it on its face that a patent is valid? Even with the presumption of validity, the presumption can be overturned, and therefore there's plenty of room to think that patents can or should be invalidated, and we don't necessarily want to foreclose that option. Now, admittedly, with the new administrative proceedings, they may be more effective and efficient ways of dealing with that question. And as I answered earlier, whether they should be required, I think, is a fairly controversial question and not a completely clear question. But in terms of just the dynamics of litigation, they may be the way in which they can be enhanced. Certainly, as a very efficient manner, they may be more efficient than something like a declaratory judgment action or the defense of patent invalidity in an infringement action. But we'll have to wait to see how that discussion plays out in the Quozo case, which would be the subject of our next webinar in about a month, April 21. And so, in that case, the Quozo case is up for oral argument on April 26th. And so we'll have some further discussion, of those particular issues. So the implications for patent law reform are not as neat as maybe sometimes comes up. We'll wait to see what Congress also does on this front, and especially if the court does overturn Seagate, whether Congress does respond in some ways to give some more structure to what would just end up being a totality of the circumstances approach to to willfulness and enhanced damages. Very briefly, there's always the relationship between the Federal Circuit and the Supreme Court. The basic tension is that the Federal Circuit is viewed as, or maybe views itself as, in some situations, as the Supreme Court of patent law based upon its expertise and its particular mandate. The Supreme Court is more of a generalist court. And they do come to loggerheads in cases like this one, where the Federal Circuit does create special tests like it did in Brook Furniture before Octane Fitness, and as it's done in Seagate, while the Supreme Court, I think, well articulated by Justice Roberts, really thinks about the generalist judge and really thinks about the discretion that's given to the district court. Just based upon Justice Roberts' questioning, it seemed like the Federal Circuit may have been losing on that front in the oral arguments. And even Justice Breyer, who was defending the Seagate approach for the most part, was not doing so on the grounds of the Federal Circuit's expertise. I think there was some discussion of the Federal Circuit's expertise, but that was minimal compared to Justice Breyer's concern with the litigation effects of making it more difficult to get enhanced damages. So let's now talk about what the implications might be for responding to cease and desist letters. I think there's a real problem with the totality of the circumstances test from this perspective, because we never know what a district court judge might do, right? So either way, ignoring a cease and desist letter might lead to a finding of willfulness, even if there is a finding of potential patent invalidity. At the same time, responding to the cease and desist letter and continuing to use the invention might also be a basis for willfulness. And this is one of the big problems with the totality of the circumstances approach, which I think Justices Sotomayor and Kagan were emphasizing. What exactly is the standard? Do we have anything to go by? With the current approach, even factoring in that it may not be favorable to patent owners, keep in mind that we're all on either side of the V in these cases, right? And so, if you're trying to aggregate the net effects on all inventors or on all startup companies, we need to keep in the effects on both sides of the current standard. So even if patent owners are disadvantaged, there is something to this emphasis on objective prongs. And so if the cease and desist letter does consist of, well-informed reasons for thinking that the patent might be invalid, again, written and couched in a way that's appropriate for cease and desist letters, or does give rise to opinion letters of counsel as to patent validity or as to a liability for infringement, that seems to provide a bit more guidance for the recipients of cease and desist letters as to what to do, at least on this issue of how to avoid enhanced damages. So I think that's the totality of the circumstances approach probably is more fraught with pitfalls in this area than the current law, even with all its disadvantages. And that finally is probably what might be good for technology commercialization and startups. Patents can be a blessing or a curse, as we well know. If we just take for granted that some patents should not have been granted, if that's the big problem, that some sort of technology might be locked up or a patent might be used for frivolous litigation or some sort of hold-up value, then there's something to be said in favor of the approach that's been adopted by the Federal Circuit in terms of trying to at least create a culture where patents are looked at a little bit more critically, and there's a lot more development in understanding of the prior art and the patentability of various innovations. And that can inure to the benefit, I think, of technology commercialization and startups. And so from that perspective, we, I think, are better off having a system that gives patents to the right inventions, and gives patents to the right inventions in a way that people can trust and say, okay, there is a presumption of validity in the law, but there's also a presumption of validity in my mind when I look at this particular type of patent. And that would be generally more healthy for the process of technology commercialization and startups. And arguably the Seagate standard, with its imperfections, might be getting us there, again, as opposed to a totality of the circumstances approach. And so lots of open questions. I appreciate the questions that have been asked. It's about 1 p.m. now, and we have some time to go, 2 p.m. now, excuse me. So we have some time to go over to take any other questions or points of discussion people might have. But I appreciate your attention. I'd be glad to clarify anything either here or via email later on. And I look forward to having you attend the next webinar on April 21st that deals with the Quozo case, which we touched upon briefly in our discussion today.
Just to give people some time if they want to send in questions, I was wondering if you could clarify, I believe you said the design around is sometimes evidence either of infringement or of an attempt.
Of willfulness, yes, yeah. Well, design around, I mean, that design around is, it's a complicated term of art. The fact that an infringer or alleged infringer tried to design around, but then use the invention anyway, might weigh in favor of willfulness. As a general matter, design arounds can be desirable because they can lead to other inventions if, in fact, they're successful. And what I mean by design around is coming up with the same way of the functionality of a particular invention without actually using the invention. Okay, so the design around that's unsuccessful and then leads to the actual use of the patented technology. So evidence of activity of design around suggests that the parties, the alleged infringer, did think that the patent was valid. Otherwise, they would have just simply used it directly.
There being no further questions, we'll conclude this webinar at this time. Is that correct?
Okay.
As Professor Ghosh said, if you would like to forward any questions to us at I think the last
yeah, slide, that's right. I have the slides.
NYS STLC.
Okay, it's not coming up.
SYR.
Can you get to the last slide, Joe? Or okay, didn't have a last slide. Okay. All right. No, I appreciate your attention. I really enjoyed doing this. I hope things were laid out in a clear way, and I look forward to hearing from you for any suggestions of future topics or any questions or responses to things I talked about in the last hour.